Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. The Department of Labor will no longer enforce the Biden-era independent contractor rule. The rule tightened restrictions on classification of workers as independent contractors under the Fair Labor Standards Act. The department will now revert to the less stringent economic realities test. However, the 2024 rule has not been rescinded and remains in effect, which means that it continues to apply to private litigation. Other federal agencies that classify workers may also interpret the rules differently, and some states have their own tests. Employers should continue to follow the guidelines applicable to their situation. The proposed 2024 EEO-1 Component 1 collection season is scheduled to begin May 20th with a deadline to file by June 24th. As expected, Component 2 pay data collection will not be required this year or in the coming years. It is unclear whether federal contractors with 50 to 100 employees must file. One significant change this year: employers will no longer have the option to categorize employees as non-binary. Relief for New York employers. Last Friday, New York Governor Kathy Hochul signed into law a budget bill that includes an amendment to the New York labor law. The amendment dramatically limits the relief employees can seek for first-time violations of frequency of pay provisions. Rather than the current potential amount of 100% liquidated damages, employees are limited to lost interest on delayed payments for an employer's first offense. This takes immediate effect and applies to pending and future actions. And finally, a reminder for New York City employers: the new requirements for physical and electronic posting of lactation room accommodation policies are in effect. That's it for this week. Thanks for listening, and we'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.